Associate Professor in Public Law at the University of Cape Town, Cathy Powell, joins us. Professor Cathy, good evening to you. Thank you so much for your time tonight. This assertion by Waluś's lawyer that there will be no different outcome that the minister can make that would result in his client being released, is that fair comment, you believe? And that kind of argument before the court of law, how would one actually substantiate it for it to be admissible before the court?
It's actually plausible based on the reasons that the minister himself has given for refusing parole. So the minister in his submission to the Constitutional Court said that he accepts that Waluś feels remorse, he accepts that there's a low risk of reoffending, but he made his decision to refuse parole based on the severity of the crime for which Waluś is serving life imprisonment. So because it was such a terrible crime, because of the comments made by the court when he was sentenced, for that reason, he can't get parole. Now, the point that his lawyer is making in that clip is if that's the reason, then Waluś can never change it. So the fact that he's meeting all the other requirements of parole is never going to help. There's nothing Waluś can do about the nature of the crimes that he originally committed. So that's one of the reasons why his lawyer is claiming Waluś is never going to be set free on parole. They've also referred in their submission to the court to a long range of irregularities and irrationalities in decisions made about his parole. But I think the main point now is simply that parole is being refused on bases that he cannot change anymore.
Cathy, when we look at what has happened before when it came to the denial of parole, of course, there was great involvement in terms of what the Hani family had to say about the release of Janusz Waluś. And in fact, Chris Hani's widow, Mamdimpo Hani, would consistently talk about the fact that she believes that he has not been forthcoming in telling the truth about what happened, and therefore that should be enough reason for him to stay behind bars. When you look at what the future of this case is going to be, how much weight is that going to hold going forward?
Well, for the parole board and for the minister, the views of the victims are one of the aspects that gets taken into account, but are not the only ones. The assertion by Chris Hani's widow that he wasn't forthcoming and that there's no real remorse and that he will kill communists again, those are what the victim feels, which is a perfectly understandable subjective response, but the parole board and the minister will compare that with the reports of psychologists who've said the opposite. So that in itself, what the victim's family feels, need not be determinative. It is one of the factors to be considered. You
also have one of the big organizations in the country, the South African Communist Party, that is among those that is opposing this particular application. And again, in very much the same breath as Dimpo Hani, they do not accept Waluś's apology and continue to call for greater truth or transparency, as they believe the truth has not been fully spoken. There's no question about the fact that this case becomes a very emotive case, particularly given the history of the country. In terms of the Constitutional Court and how they will decide here, what do you think are going to be some of their key considerations?
Well, the lawyers for Mr. Waluś are making an interesting argument based on, in fact, a comment made by the Supreme Court of Appeal in a related matter, that if you have life imprisonment without the possibility of parole at all, then you have cruel and inhuman punishment. The SCA said in a previous case that it is the possibility of parole that renders life imprisonment constitutional. Now, what's interesting in this case is they're not attacking life imprisonment as a sentence directly. but they are saying that the existence of parole, the possibility of parole, is the only thing that makes life imprisonment constitutional. And therefore, parole has to be interpreted and understood and applied such that the mere nature of the initial crime cannot be all determinative, because then you would get crimes for which there is no parole. So that is a new constitutional argument, and the court may well choose to engage with it, to take a position one way or the other. But remember, it was the Constitutional Court that declared the death penalty unconstitutional for overturning certain values in the Constitution. In effect, they are being invited to do the same thing with life imprisonment without the possibility of parole. What Mr. Waluś's lawyers are saying here is that, in effect, what's actually taking place here is that he will never get parole.
All right.
And if that is the case, then he's being subjected to cruel and inhuman punishment. And it's worth hearing what the court says about that.
All right.
What I also noticed, thank you, that there are a lot of other prisoners who are serving life imprisonment who have actually applied to address the court on the same matter, because their problem is that they are not getting their parole applications heard. So the brokenness in the system whereby paroles are processed is affecting not just Waluś, but I think the figure in the submission was 4,000 prisoners.
All right, so it could have a much broader impact than just for Janusz Waluś in this instance. Associate Professor in Public Law at UCT, Cathy Powell, thank you for your time.